Hi, and welcome to a special episode of The Eagle, a Times Union podcast. I'm Jessica Marshall. On Monday night, Politico published an alleged draft of a Supreme Court decision written by Justice Samuel Alito that overturns Roe v. Wade, the 1973 decision that grants the right to an abortion nationwide. To discuss the implication of this news, Times Union Editor-in-Chief Casey Seiler and health reporter Rachel Silberstein checked in with Albany law professor and constitutional law expert Vin Bonventre. Here's their conversation.
Hi, and thank you for listening. I'm Casey Seiler, editor of the Times Union. We are talking Tuesday morning, the morning after Politico reported on a fairly remarkable draft of a majority opinion written in February, as Politico has reported, by Justice Samuel Alito that would overturn Roe v. Wade. And as Politico has reported, it is apparently the opinion of the conservative majority on the court. I am happy to be joined by Vin Bonventre, the Justice Jackson Distinguished Professor of Law at Albany Law School, an expert in constitutional law and the Supreme Court, and Rachel Silberstein, our health reporter and a former Capitol reporter as well. So, Vin Bonventre, if this draft ends up being absorbed in large part in the majority decision when it is issued, what are the implications beyond simply, although simply is probably not the word here, sending the question of whether abortion should be legal to the states to determine?
Sure. Well, first of all, if the Supreme Court overrules Roe versus Wade, if this supposed majority opinion retains its majority, then what will happen is Roe versus Wade, the right of a woman to choose to have an abortion, will not be a federal constitutionally protected right. That's what it means. Now, when the Supreme Court says that there is no right to choose, right of a woman to have an abortion, what they are simply saying is that, and the only thing the Supreme Court has authority to say, is that if a state wishes to prohibit abortions, that does not violate the federal Constitution, right? So the Supreme Court cannot say, there's absolutely no right to choose, there's no right to an abortion, states, you cannot afford such a right. No, the Supreme Court can only say that laws that prohibit abortion do not offend the federal Constitution. So that's what this would mean. So it would be kicked back to the states, or it would be kicked to another branch of government, so say Congress, with the signature of the president. They could restore as a statutory matter, right, what Roe versus Wade made into a federal constitutional right. So I don't mean to belittle the implications of overruling Roe versus Wade, but it doesn't mean that there's no right to abortion in America. It just means that the Supreme Court is saying that, in our view, the federal Constitution doesn't protect any such right.
In terms of how it interacts with New York, which has, comparably strong abortion laws, can we expect basically no change from if the opinion passes?
Well, in many states, whatever the Supreme Court does will make absolutely no difference whatsoever, except in the political arena. So, for example, it would certainly give more conservative politicians much more leeway to argue against, a right to choose, a right to an abortion, because now they can say legitimately, that is, if this supposed majority opinion is in fact real, the conservative politicians can say that we do now have the right to ban abortion in our state, right? Which they haven't been able to say up until this point, right? For the last almost 50 years. So the conservative politicians certainly will be aided by the Supreme Court overruling Roe versus Wade.
So right now it's a draft opinion, right? So it's not law. To what extent does this opinion, in your view, conform with the views of the Supreme Court, the majority of the Supreme Court?
Well, it's supposedly a draft majority opinion written by Samuel Alito, and it certainly sounds like him. Samuel Alito has become increasingly militant, acerbic, angry in his opinions, and this sounds like that. I mean, this is a no-holds-bar opinion. It's not just that he's saying that, well, on balance, we think that it's better if we leave the right to choose to the states. No, I mean, he's just saying Roe versus Wade was an outrageous opinion. It was absolutely wrong. There was absolutely no basis for what the Supreme Court was doing in Roe versus Wade. And it was wrong from the beginning, never should have been decided that way. And finally, we're doing the right thing and saying that Roe versus Wade was nonsense, and we're getting rid of it. That, of course, totally disregards the fact that it was a 7-2 decision back in 1973, and the majority included several Republican-appointed justices, and the fact that it has survived for 50 years, and it has even survived with a majority of conservative Republican appointees on the court. So, for example, it survived in the Planned Parenthood, the Casey decision, right, with Sandra Day O'Connor expressing the view that the right to choose was protected against any undue burden. So this is a right, that is a right of a woman to choose to get an abortion. It's a right that is pretty well established in American jurisprudence. So this is quite stunning if in fact Roe versus Wade is overruled the way this supposed Alito majority opinion, if that becomes the ultimate majority opinion.
So to that point, this would also seems like it would be a significant break with the principle of stare decisis that precedent
That's
should
right.
stand. A significant conservative beef with Roe versus Wade is that it essentially, the argument is that it created rather than identified a right to privacy within the Constitution. And what other issues or rights might, if that right to privacy is essentially determined not to be there by overthrowing Roe v. Wade, what other rights or issues could be implicated? I've seen sort of very quick analysis that
Right.
it could affect people's right to obtain birth control, contraception, and that even gay marriage could be once again sent back to the states as opposed to being a nationally identified right.
The arguments in the opinion, in this supposed majority opinion, are arguments that certainly could be used against many landmark decisions. But let's step back for a minute. The major arguments here are that there's no right to an abortion mentioned in the Constitution. And let me just be outright about that. That's just a moronic argument. Most of our fundamental rights are nowhere mentioned in the Constitution, right? The right to have a friend, the right to be married, the right to be intimate with your spouse, the right to have children, the right to raise your children. Oh, come on. Most fundamental rights are nowhere mentioned in the Constitution. In fact, one of the major concerns of the framers of the Constitution was that if they had a Bill of Rights and they started enumerating certain rights, some people in the future, as we continue to hear, will make this moronic argument that, well, it's nowhere mentioned in the Constitution and therefore people don't have that right. That is an absolutely moronic, worthless argument, but we keep hearing it all the time. And in fact, to safeguard against that, the framers put in the 9th Amendment. They put in and said, just because we listed a few here, that's not an exhaustive list, but we still hear that nonsense. The other one is that, well, right to an abortion is not part of the tradition of this country. So it's not mentioned and it's not part of the tradition of this country. And that gets to your question. Okay, Prohibiting racial segregation was certainly not part of the tradition of this country in 1954, when the Brown versus Board of Education was decided. The right to use contraceptives, even for married couples, that was not part of the tradition. It's not in the text, and it's not in the Constitution. The right of interracial marriage, that's not mentioned in the Constitution, and that certainly was not part of the tradition of this country. Gay rights, that's certainly not mentioned in the Constitution, and it's certainly not part of the tradition. In fact, virtually every single landmark decision is a landmark. Our cherished landmark decisions, they're landmarks because there isn't anything clear in the Constitution which guarantees what these landmarks protect. And these landmarks, the rights that they protect, were not part of the tradition of this country. You know, I tell my students, and they're shocked at it, it wasn't until 1971 that the United States Supreme Court finally came out of the caves and said that women were entitled to constitutional equal protection. 1971. So up until that time, it wasn't part of the tradition of this country either. And the Congress certainly would not have passed the 14th Amendment, which guaranteed equal protection, if it was said at the time, oh, by the way, we're going to end racial segregation. Oh, by the way, we're going to end laws against interracial marriage. Oh, by the way, women were going to be treated equally and have the right to vote and all the other rights of men. Those things never, the 14th Amendment never would have been enacted. So none of those were part of the tradition of this country. So some of the arguments are kind of nonsensical, but that's not to say that there aren't good arguments. And Samuel Alito is extremely bright, and he does have good arguments. He speaks about the fact that, there are different interests. There are different interests that have to be balanced. But ultimately, he comes down on the conclusion that because there are different interests that need to be balanced, that ought to be left to the states. Well, that is, that's a legitimate argument. Although, would we say the same thing about the right to counsel, about the privilege against compulsory self-incrimination, about free speech, about freedom of religion? Well, these things are controversial. Leave them up to the states. No, we wouldn't say that, about those things. So, look, these issues are difficult. They involve a conflict of two different, very important interests. On the one hand, bodily autonomy, liberty, freedom on the part of the woman. And on the other hand, government's very legitimate interest in protecting human life and not wanting to allow that slippery slope where, human life is devalued. So there are important interests here on both sides.
I mean, circling back to whether this opinion reflects the majority of the Supreme Court justices, it sounds like your short answer is no, not this specific opinion doesn't sound like anyone besides Alito.
It does sound like an Alito opinion, but I would be surprised if Clarence Thomas, Gorsuch, Barrett, and maybe even Kavanaugh joined that opinion. I mean, it does sound to me like, Alito got the majority, and this is the way he's going to write the majority opinion. One thing that's really fascinating, by the way, is if Alito is writing the majority opinion, that means somebody must have assigned the majority opinion to him. Alito doesn't have the authority to choose to write the majority opinion. So either Chief Justice John Roberts assigned him the opinion. That would mean that Chief Justice John Roberts is in the majority. If Roberts is not in the majority, that means the senior associate judge would have assigned Alito the majority opinion, and that would be Clarence Thomas. So either Roberts or Thomas assigned Alito the majority opinion, which is pretty interesting. If it was Clarence Thomas who assigned Alito the majority opinion. That means that at least originally, Roberts was not in the majority.
So on the subsidiary question of the leaking of this draft, which Politico said was from February, how much of a breach does that represent from Supreme Court and really sort of judicial protocols? And what are the either professional sanctions that the leaker, if identified, could face, or even criminal, sanctions
Right.
that person or persons, I guess, could be confronted with?
Well, first of all, with regard to leaks, there are always leaks at the Supreme Court, and this is hardly the first time that an opinion was leaked. In fact, as the Washington Post points out today, the Roe versus Wade itself, the majority opinion there had been leaked, and parts of other opinions and decisions in cases had been leaked previously. I'm pretty sure that the Watergate's tape decision that was leaked previously. The Pentagon Papers decision, I think that was leaked beforehand. These things happen, and we've had books about the Supreme Court, about the inner workings of the court, and those books were only possible, and also the columns by some such as Linda Greenhouse and Joan Biskupic. Those columns can only be written, those books can only be written because there were leaks. There were individuals who broke the rules of confidentiality, and they revealed, the inner workings of the court. Now, as far as a lawyer is concerned, suppose this was a law clerk that leaked this opinion. Well, certainly that law clerk could be disciplined under the rules of professional ethics. Now, whether there's actually a federal statute prohibiting this, I'm just not sure about this, because we're not talking about a leak that affects national security. We're not talking about that. We're really talking about professional responsibility here that has been breached. But obviously, it's major. You don't get something like this all the time.
Well, we really appreciate your taking the time, Vin Bonventre of Albany Law. It's always great to get that kind of deep background from a veteran scholar. So thanks so much for taking the time.
Hey, great to be with you. Thanks for inviting me.
For more on this and how an overturn of Roe v. Wade would affect New York, head on over to timesunion.com. And that's it for now. I'm Jessica Marshall. We'll be back again soon with another look inside the newsroom here at the Times-Union. In the meantime, check us out on Facebook, Twitter, YouTube, and Instagram, or head on over to timesunion.com for the latest news and features. The Eagle is a production of the Times-Union. It's produced and edited by me, Jessica Marshall, with help from the Times-Union digital team and the newsroom. Special thanks to Casey Seiler and Rachel Silberstein for their contribution to this episode.